Call our meeting to order here, the Senate Regulated Industries Committee. Welcome, everybody. We had a relatively aggressive agenda today. I'm having some senators, after having gotten their bills on our agenda, begging off. Maybe they not as ambitious as they thought. So we may not hit all of these bills. I'm going to start. We're just going to go in order as on the agenda. Start with Senate Bill 81. Senator Brass, I had a request from Senator Huffstetler that he go first at one point because he has a meeting in the governor's office at 4:30. When we got backed up due to our late, adjournment today on the floor, he's asked me to move him down so maybe he can finish that meeting up and get in here next. So we'll start with SB 81. Depending on if he's back or not, we'll do Huffstetler's bill, then we'll go to 112. Senator Dixon, Senator Walker's bill will not be heard today. So, Senator Brass, you're welcome to take your seat of honor either at the podium or right there at the witness stand and walk us through this briefly. Whatever suits you the best, fine with us.
This is fine right here, Mr. Chairman, if you're okay with this.
I am. This will be the first bill in your folders, and committee members, you will note that there is an amendment. Was provided to me on Friday, and apparently that's after some negotiations between the automobile manufacturers and the dealers. I'm told by lobbyists for both sides that they've agreed to that, and it is not controversial. But you can go ahead and speak to that as well, too, if you want to.
Sure, Mr. Chairman. Just to kind of give the committee a kind of an overview of these. You know, these laws are really fought on a state-by-state basis, and my understanding is in Georgia there's a lot less of a we'll call it a headbutting, and I think I attribute the dealers and the manufacturers, they get together on the front end and work out their differences, or at least as much as they can. And so that certainly makes our job easier. And when it was approached to me to carry this bill, that was one of the questions I asked. Is I always ask who's the opposition, and so that was, I now have an understanding of the opposition, and there is not much opposition. There's a few little nuances still to work out. I do have an amendment, and I'll discuss that later at the appropriate time. But really, a brief history of Georgia's first Motor Vehicle Franchise Practice Act. Senate Bill 81 is a modified version of Georgia's first Motor Vehicle Franchise Practice Act. All 50 states have enacted a franchise law. Georgia's General Assembly passed Georgia's first Motor Vehicle Franchise Practices Act in the mid-'70s. In 81, it was the intent of the Georgia General Assembly to substantively reenact new motor vehicle franchise legislation, and several amendments were added over the next decade. In 92, Georgia's Constitution Amendment 6 was passed by a 60% approval, authorizing the Georgia General Assembly to regulate the motor vehicle dealers, manufacturers, and distributors to prevent unfair business practices. So the law has been amended 7 times over the last 30 years, and the last amendments were passed in 2019. Just kind of a broad overview of the actual bill. There's really 5 key areas. There's legislative findings, data protection, over-the-air updates, also known as OTAs, allocation, and then showrooms/galleries. So in the first part, the legislative findings, the proposed changes to the legislative findings would reflect recent industry changes in legislative intent. And so those are proposed amendments include adding recall service to the list of services of substantial concern to the public, emphasizing the benefits of competition within the franchise system for consumers, including competitive pricing, service, and convenient repair facilities, highlighting additional benefits of local dealerships, such as introducing new automotive technology, supporting and maintaining vehicles after sale, protecting against monopolies, and providing stable employment. Second part is around data protection. As we know, data data is a very important commodity, and it's a very precious commodity. And dealerships handle significant amounts of sensitive customer data. This legislation would address concerns about data access and security between dealers, dealer management systems, and vendors. The proposed amendments aim to prevent unauthorized access, sharing, or selling of dealership data from their dealer management system, prohibit third parties from limiting a dealership's ability to protect, store, or use that data, and then allow data integrators to access data on a dealership's DMS for specific services, provided they comply with industry standards for secure data integration. Permit dealers to continuously monitor or audit data access from or written to their data systems without interference, and allow dealers to back up data and implement redundant systems for business continuity in case of security breaches. So the changes are designed to promote competition in data management and integration and help dealers secure and monitor third-party access to ensure customer data protection. Now, the over-the-air updates, the OTAs, the increasing use of OTA updates has raised questions about the role of dealerships in consumer protection. So this legislation is going to require manufacturers to compensate franchise dealers when dealers assist customers with OTA updates, require manufacturers to disclose to dealers each accessory or function of a new vehicle that may be initiated, updated, changed, or maintained through OTA updates, along with the associated cost to the customer. And this information can be provided digitally or on the manufacturer's website. These changes aim to ensure fair compensation for dealer services and transparency for customers or consumers regarding OTA updates and their cost. Fourth section is around allocation. The vehicle allocation is the process by which manufacturers distribute inventory and parts to dealers. It's crucial for the dealer's success. This legislation aims to bring more fairness and transparency to the allocation process. So defining a reasonable quantity of vehicles as fair, equitable, and non-discriminatory against line make dealers. Increasing transparency in the allocation process to provide dealers with a better understanding of how it works, and clarifying that manufacturers' inability to meet allocation standards due to factors beyond their control. You know, for instance, a natural disaster, or maybe the unavailability of a part, which we have all seen over the last several years. All these take place in Georgia. So the final and the fifth is around showrooms and galleries. So in Georgia, new car dealers cannot engage in an activity as a new motor vehicle except at their dealership or a temporary site for which it receives a permit from the Department of Revenue. So despite that, some companies have opened showrooms or galleries at which vehicles are displayed and demonstrated without obtaining a dealer's license, raising questions about whether they are engaging in the business of a new car dealer without the required license. So this legislation really clarifies the law around defining what is a specific activity and engaging in the business of a new car dealer. So it does that by selling, leasing, offering to sell or lease, negotiate terms, accepting deposits, processing reservations, and accepting or negotiating trade-ins. Again, these are what's included under defining what engaging in the business of a new car dealer is. Displaying vehicles alone or disclosing the MSRP would not constitute such activity. And I think a good example, I believe up at what's the old Sears place? Ponce City Market. I believe there's some vehicles displayed there. And then if remember in the old days, the malls used to have vehicles displayed there. So this clearly says that you can do that. You just can't have somebody there trying to make a sale. So, and it would be fine to disclose that MSRP. So again, this proposal aims to distinguish between sales activities, which do require a license, and simply displaying a vehicle which does not require a license, providing clarity for both manufacturers and dealers. And then I can discuss the amendment at the appropriate time, Mr. Chairman, whenever you tell me.
We'll go ahead and do that now if you want to.
Okay.
Because it just explain it as if it's already built into the bill. Do you need a copy? I got one in
No,
the folder.
yeah, I got one right over here. All right, thank you. All right, so section 2, line 102. So this technical amendment maintains consistent use of terminology throughout the bill because we're changing distributor to affiliate thereof, really affiliate. So same thing on section 3, line 167. Section 4, line 316. Kind of the same thing. It keeps the terminology used in the paragraph consistent. Section 4, line 318. This amendment considers mobile services. Excuse me. This amendment considers mobile services offered by dealers, and it's necessary to ensure dealers don't service or assist customers outside of their designated authorized territory. For example, ensures mobile service providers don't service customers in their competitors' territories. Section 6, lines 398 through 406. This new language clarifies that manufacturers may continue managing offering new vehicle reservation systems to customers as long as the price and the terms of the sale are negotiated and executed directly between the customer and the dealer. The new language in subsection 7 of that clarifies that manufacturers may continue fulfilling sold order requests for customers as long as the price and other terms of the sale are negotiated and executed directly between the customer and the dealer. And then a sold order refers to a vehicle order that has been confirmed as sold, meaning the customer has committed to purchasing it and the vehicle is in the process of being delivered or built. Once a vehicle is sold, it transitions from being an unsold inventory vehicle, which may still be available for sale, to a sold order, meaning the vehicle is reserved for a specific buyer. I can give an example of that if anybody wants it.
All right, hit it.
So if a customer wants to come in and buy, say, a 2025 GMC Sierra AT4, good truck. However, the dealer doesn't have one available on the lot, so the customer may place an order for the truck through the dealer. Once the order is confirmed and the customer agrees to the purchase, the vehicle status is updated to sold order. GM begins manufacturing the truck, and once it's ready, it is delivered to the customer via the dealer.
Okay. Do any committee members have a question for the sponsor of the bill, Chairman Brass? All right, we have a few, you got a question there, Senator? Again, you're recognized for a question.
We got some industry experts here, too, that maybe can answer something I cannot, but I'll give it a shot.
Thank you, Mr. Chairman. I look over here on line 63, and it starts talking about affiliate, and I looked up definition of affiliate on Google, and I'm thinking, okay, we don't define affiliate in the bill anywhere that I can see. I don't know if it's in the code section already existing right now. But I see affiliate used several times, and you're adding it into a couple more places, and I don't know if it's already listed in the code section, but there's different definitions. What I see in Google, your friends are telling me that it is defined in code, so that's a good thing.
I was about to say the same thing.
They beat you to it.
They did. Let's get some order in here. You're stealing my answers. I'm just kidding, Mr. Chairman.
He'll be begging for
Are you going to ask him for the definition of an affiliate in the underlying code?
If he says it's in there,
It's in
I'm
code.
okay as long as it's defined. I just.
Okay, you don't care what it is, as long as we all know.
Well, I'm gonna take my guess that his intent here is to move the bill forward.
That's a pretty good guess. Sponsors usually do.
So I don't know if
he wouldn't be here otherwise.
Well, let me get you off the hot seat. Well, okay, Vice Chairman's got a question for you. Senator Summers?
Chairman Brass, just curious now, somewhere down the line, other states, does this bring us in line with other states? Is that with a franchise bill? How's that work?
I'd say similar to some other states. I mean, I'll let the industry experts
Fair enough.
comment. They
Thank you.
can speak to that better. I kind of focus on Georgia.
Thank you.
All right, we have 3 people signed up to speak on this, and they are representing all parts of the, sort of the food chain here. We have the Georgia Automobile Dealers Association, Mr. Ben Jordan. Ben, if you'll come forward. And then we'll hear from Rusty Sewell, who represents all of the auto manufacturers, their organization, and then Reagan Marsh, who represents General Motors. So we'll be getting perspectives from both the dealerships and as well we'll be hearing from the automobile manufacturers. Your mic is live. Go ahead and introduce yourself, Ben, and then give us your views on the legislation. And you have talked to me privately a little bit about the history. You might flesh that out for us a little bit more so we understand why automobile dealerships have a law that regulates their franchise relationships, and Zaxby's and McDonald's and everybody else in the world that's a franchisee doesn't.
That's right.
All right.
Well, thank you, Mr. Chairman, members of the committee. Ben Jordan on behalf of the Georgia Automobile Dealers Association. We stand in support of Senate Bill 81, and I'd be happy to answer that very good question and several others raised. But if you don't mind, Mr. Chairman, I just wanted to acknowledge a couple of our special guests with us. Working from your left to right, we have Mr. and Mrs. Mike and Aja Dominicone from Classic Cadillac and Subaru in Sandy Springs. To their left is Miss Grenee Barenko from Mercedes-Benz of Buckhead and soon-to-be Audi Forsyth County. Behind Ms. Barenko is Mr. Jim Hardman from Jim Hardman Buick and GMC in Gainesville. To his right is the one and only Bill Morey, President and Emeritus of GADA. To his right is young Travis Johnson, our new Director of Government Relations, formerly a college football player, very bright young man, now with us full-time. And behind them is all of our bosses, Miss Leah Kirshner, President and CEO of GADA. Mr. Chairman, you raised a great question, and it's one that we get often, which is why? Why does state law regulate the relationship between automobile manufacturer and local franchise dealer? And the answer to that simply is David and Goliath. Automobile manufacturers employ tens of thousands of people. They generate billions of dollars in revenue every quarter. They operate in multiple countries, whereas local dealers here in Georgia employ on average 70 Georgians. And while they are very important to their local communities and to their local economies, in dealing with relationships with their manufacturer, one local dealer versus one large manufacturer, it's a one-way street, and the manufacturer determines the terms of that agreement. So what do dealers do, and what can they do if they wanted to change some terms of that agreement? Well, dealers of the same line make cannot get together and try to collectively bargain against their manufacturer. So Ford dealers, for instance, cannot get together with other Ford dealers and try to change the terms of all of their agreements with Ford. Federal law considers that a very big no-no for antitrust reasons. So what they're left with, dealers, is basically their constitutional rights, their rights of assembly. They can join associations like GADA. They have the rights of speech, and they have the rights to petition their government for a redress. Hence, the vehicle franchise laws, as Chairman Brash said, every state has a franchise law. Chairman Brash did a great job going through the history here. Mr. Morey knows it well. He's lived through many of those bills. But we've had a Georgia franchise law in here since the early 70s. Every state has one. But Georgia is unique for 3 reasons. The state constitution actually gives you, the General Assembly, the power to pass these laws to regulate the relationship between manufacturer and local dealer to ensure the consumer benefits from that relationship. As Chairman Brash mentioned, we're also unique in that we do not ask the General Assembly to update the franchise law every year. Some states do. The last time this set of laws was updated was in 2019, a bill that passed through this committee. We're also unique, as Chairman Brash mentioned, in that before we come to the General Assembly, we go to our business partners, the manufacturers, first to start the discussion and to see what issues we can iron out easily and see what issues might take a little more time. In this instance, we started those conversations in late October. even before the election. Those conversations have continued through November and December and January and now into February. And what's before you, including the amendment, is a version of the legislation that is different from the one initially drafted, one that is filled with several compromises and hopefully some improvements, because believe it or not, the dealers are not the only ones in the automobile industry. There are our business partners, the manufacturers, and there are most importantly the consumers. The question was raised if any other states have provisions in their code similar to these, and I can assure you that's the case. One reason Georgia does not ask the General Assembly to update the franchise law every year is because we like to see what other states have done and see what works and adopt maybe a best practices. So in that spirit, every one of these provisions, almost every phrase comes from another state with just a few exceptions, and I did want to highlight one, and it has to do with data. There's a provision in this bill that allows dealers to back up their data in order to restore operations in the event of a massive cyber attack or other event that renders their operations inoperable. You might ask why we want to be that specific and why that's needed. Well, last June, there was a cyber attack that involved a very large data management system company. And that data management system company had such a hold over all the customer data on these dealership management systems, and they had such a large presence in the market that half the franchise dealers in this country couldn't even operate any of their systems and had to go back to the old school and write out handwritten repair orders for 2 weeks. That caused approximately $1 billion in lost revenue last year in the auto industry. And it raised a couple things that, a couple issues came to light in our industry. And one is that dealers need more control over their data to do two important things: to protect it, which they're required by federal law to do, and to share it securely with authorized secure vendors in order to compete in the modern economy. And that's exactly what this bill is designed to do. That's probably the most complex and the most dense, or the densest part of this bill, but the language in this bill comes almost directly from several states, including West Virginia, Arizona. They were the first to pass these kinds of bills. Montana, Oregon, Utah, Oklahoma, North Carolina. The rest of the provisions are modeled after what several other states have done already. Chairman Brash mentioned over-the-air updates. A number of states have already passed legislation similar to this.
On that data issue,
yes,
am
sir.
I right that that's at like lines 197 to 202 or 3 in case anybody's following along up here? This committee's pretty diligent. They read these bills in detail before they get these meetings. Just want to help them out a little bit.
Yeah.
Isn't that right, Tanya? Yeah. Is that where you were talking about the data backup starting at lines 197, excuse me, 199?
I want to make sure I'm looking at the right version of this.
This is we do not have a committee
Okay.
sub yet. We'll generate one if the amendment is adopted. So I was at the bottom of page 8.
Mr. Chairman?
Yeah.
All the data stuff starts in section 3, which is line 113. And so that lines 116 through 142 are your definitions. And then it starts getting into the meat of it in 143 and beyond.
And my question is specific to the data
So-
backup system, because manufacturers control that data.
The-
Except under this circumstance, it gives you all an out
The
if
par-
their system crashes like happened this summer, right?
Right. The part that I was referencing about backing up would start at line 245. It's subparagraph F, kind of towards the last part of this section of the bill. I'm on page 10, towards
Gotcha.
the bottom of page
Okay.
10.
Subsection F down there at 245.
And you mentioned the manufacturer, Senator. We have had several discussions with them on every part of this bill. The parts of the bill that probably required the most discussion were this data portion, obviously. It's complex, and nobody wants to do more harm. And the allocation is probably part of the bill that required some conversations because, that can be a pain point in our industry. But we believe settling on increased transparency would be a very good first step for everyone in the industry. We've heard from some dealers, particularly after the pandemic, that they felt like they weren't getting nearly enough vehicles to not only to compete, but to stay in business. We think with increased transparency, that will prompt more conversations with manufacturers and help dealers who feel aggrieved because of allocation understand what's going on and why, and hopefully resolve future disputes. We've also I'm sorry.
I didn't want to break your flow. You were about to go to the over-the-air information. You'd covered the data, I think, pretty good.
That's right.
Is it data or data? Somebody needs to tell me that, because we got data centers.
I probably say data.
I don't know, maybe it's where you raised.
That's where you grew up.
That's right.
I just don't want to be mispronouncing something here. We're on national TV on these committees nowadays. I want to talk about that old redneck from Macon up there doesn't know what data is.
Data.
No, I grew up in Macon. He ain't the redneck. He's the silk stocking lawyer, tort reformer.
I'll also, if you don't mind, Mr. Chairman, I'll speak briefly to the amendment. It is one that we support. It's one that came from one of the manufacturers in particular, and most of the language was just for purposes of consistency. They made some suggestions to the last part of the bill dealing with sales of vehicles from unlicensed locations. The goal with all of this was to bring some clarity to the law that currently doesn't exist, without interfering with dealers and manufacturers advertising their vehicles, taking their vehicles to the football game, putting their vehicles in a parade, utilizing the manufacturer's website to make reservations. So we support those amendments and appreciate them being offered, and I just wanted to say that on the record. With that, Mr. Chairman, I'd be happy to answer any additional questions about the bill.
Any of my committee members have questions? I think Senator Summers may on your. Who's that? Right. Okay, I'll recognize my vice chairman first.
Thank you, Mr. Chairman. Mr. Bennett, I'm just curious, electrical EVs came to us a while back, if you remember, about having dealership. They wanted to sell and did have a dealership. How does this?
This does not impact that issue directly. It is still a topic of conversation and still certainly a concern for our dealers, including the ones represented here. Right. They've invested a lot of capital to sell and service EVs. The manufacturers have too. They're selling and servicing EVs now. The market has been up and down with EVs. We're seeing increased popularity in hybrids. So we're seeing this segment of the market that includes EVs, but particularly hybrids, increasing in popularity, whereas battery electric vehicles are the increase in popularity is a bit slower, I think, than originally projected a couple of years ago. But these folks are, they're car dealers. They want to make customers happy. Mike Domenico says it and says it well. They're in the customer-pleasing business. So if a customer wants a gas truck, if they want a diesel truck, if they want a hybrid, if they want an electric vehicle, these folks will find it for them.
I believe you. Thank you.
Senator Ginn, you're recognized.
Thank you, Mr. Chairman. Let's go back to the affiliate, because I knew you had the answer, so I wanted to put you on the spot instead of the sponsor.
Affiliate, thank you, Senator. Affiliate is defined. We had to look that up. I had to look that up, and my boss Leah looked it up. So it does have a very exact definition in Title 10, the Commercial Code. That language was added at the request of the manufacturers, specifically as it relates to data, because there are affiliates of theirs who provide services to dealers, and the question became how broad is this portion of the bill in applicability. So as designed, the manufacturers were never really purposed to be within this part of the data protection. In 2019, the franchise bill that was passed actually dealt more with the manufacturer and dealer relationship as it relates to consumer data. This part of the bill deals more with everyone else and the data that's housed at the dealership on their systems.
And the reason I bring that up is because you have also added third party. and a third party can be pretty much anybody. I mean, I don't know what the distinguishing characteristic between an affiliate and a third party is, and how because anybody in this room could be a third party to
That's a very good question. I believe the answer is that affiliate has a closer connection with the company, like a
Typically,
corporate
they're-
association almost, or a subsidiary, whereas a third party could be someone that's contracted with the entity.
Thank you.
Explain to us just a little bit about the licensing of automobile dealers. This committee handles a lot of licensing issues. Does an automobile dealer have to be licensed in order to sell cars to the public? If so, why, and what's involved in doing that? I mean, it's almost like the chicken before the egg. I don't think you would go to apply for a license unless some manufacturer agreed to enter into a dealership arrangement with you.
That's right. That's a very good question. Thank you. And we did a little research on that in preparing for this legislation as well. So to my understanding, most states require their dealers, whether new or used, to be licensed. Here in Georgia, new car dealers are licensed by the Department of Revenue. They don't actually receive a license. Interesting enough, they receive the dealer tag that serves as their license. I believe the history associated with that and the policy behind it is to try and trying to protect consumers. Basically, this is a very highly regulated market, and there, of course, is a private market for automobile sales that's going to be on the used side. But there's some risk associated with consumers buying vehicles from unlicensed sellers. And I remember having friends that would buy vehicles off of Craigslist in the early days, and then find out all of a sudden that the vehicle wasn't in that great a shape. And so what's the customer to do in that instance? Well, the Fair Business Practices Act would not protect that customer if they bought it from a private seller, whereas they would if they bought it from a licensed new or used car dealer. So in Georgia, and I'm sure in other states, dealers have to be licensed primarily for purposes of consumer regulation. When we started, the conversation about sales and displaying from non-licensed locations, we looked and saw there wasn't a definition for what it actually means to be engaged in the activity of a new vehicle dealer. And the hope here is to bring clarity for everyone, all the market participants.
So these folks that have a showroom to display their products but do not take orders or sell it, can they be unlicensed?
Under this bill, they can be unlicensed as long as they are displaying the vehicle and potentially demonstrating it. But activity of a new vehicle dealer would include basically things that I think most of us associate with a car dealer: negotiating terms, talking about trade-ins, exchanging money, taking reservations. That would be reserved for those who are licensed to do it under this bill.
So that direct sales model that some of the electric vehicle manufacturers use would be outside of the licensing process?
If they have a dealer's license, then they can transact under that license. If anyone, whatever their intent, is a new vehicle manufacturer or wants to be a new vehicle dealer, then this bill would allow them to display that vehicle, but not to engage in consumer transactions related to the sale, because then they'd basically be an unlicensed seller, violating potentially not just Title 40, but Title 10 as well.
Okay. Other committee members have questions for Ben? All right, thank you for being with us. Don't leave. We may call you back if other questions arise, okay?
Fair enough. Thank you.
All right. Rusty Sewell for the automobile manufacturers.
Thank you, Mr. Chairman. We do represent, and I have represented for a number of years, even back when Maury might have had a little bit darker hair and I had more hair. We've been playing these games and doing this. But I think I appreciate Chairman Brass has kind of set the groundwork. We do have a good relationship. Now, I'm not saying we love each other, the manufacturers, and Leah yells at me every once in a while now, But we're very fortunate in the state that we do get along. I've got my counterparts in some other states that fight every year and have problems. But we did, and Ben called, we sat down. Do we agree with everything, that goes on here? No, we just soon not have a franchise bill. I mean, that's not our thing. We're not gaining, but Ben's right. You have to update these things every once in a while. I mean, I can guarantee you right now, there are going to be 25, 26 states that'll have franchise bills this year. And I guess my counterparts and the organization that I represent will work on those. But we do appreciate what we have. We appreciate the chairman in going through with this. We do agree with the amendments that have come up that, some of our counterparts have worked on. And I think you will see in this bill, one of the things I was sitting there listening to, a lot of this bill is not necessarily things that are between the dealer and the manufacturer. Some of these, the sales outside, some of the backing up their data, because it is their data that they're backing up. These are things that are very important to them. We're involved to make sure that the changes to the franchise law doesn't, affect how we work or how we manufacture and sell cars to them. But we appreciate our dealers, and we're not trying to get rid of them in any way. And as y'all have known from the past, when we've thought about the issues that I think Senator Summers brought up, when I remember, we're glad to have this relationship and answer any questions. Unfortunately, I'm not sure how much good answer I will give, but I will try my best.
All right. Well, so from the manufacturer's perspective, why did y'all feel like you needed to update your law? Was there something of particular importance to you that our previous law had been silent on, or that you're changing? Whole bunch of this deals with the data section. I just wonder why did we suddenly feel after 5 years this time we all agree we better do something to update it?
Well, these are started by the dealers, not the manufacturers. I mean, they're looking at other states and what other states have done and involved. It's not necessarily us saying, hey, we need to update the franchise law. It's not like, like I said, we'll go back to the franchise law in 1970 if you want to, or do that. But the dealers are the ones that have to operate under this most of the time. And as I said, some of these things are not even relationships between the manufacturers and the dealers. And so they're looking at, so it wasn't necessarily us saying, yeah, we need to update the data sections and all like that, which was a major part of the last franchise bill. But it's when Ben calls and Bill and Leah, and they call and we want to sit down and go through, they brought up a lot of the issues and involved with that. We're looking at it to make sure that it doesn't affect. Data is very important, as we all know. And what we're looking at is making sure there's no problems, that it doesn't affect how our manufacturers, because you've got different, 15, 16 different manufacturers. They do run their business model differently, each one. So we work with them to do that. So it's not necessarily us bringing it up, Mr. Chairman.
Okay.
We're working with them. Once they bring it up, we're happy to work with them, and that's what we've done.
All right. Kind of their equivalent of collective bargaining, since antitrust laws prohibit them from colluding. They can only do it through amending the law or persuading us to amend the law.
It is, and Ben did a good job of explaining. I actually go back, I was in the Attorney General's office when the ruling came down, not my client, when they ruled unconstitutional a franchise arrangement early on. And it is a unique business. It's not a Zaxby's or Chick-fil-A. The franchise that we talk about here is a different kind of thing than those kind of things. And what you're passing is the basis of then when GM or Toyota or whatever has a relationship with a dealer and they come up to an agreement, this is the basis of that agreement.
Okay. I got 3 questions you got to clarify, and then we'll let you go.
Sure.
1, affiliates. This is in there for you guys. These are not affiliates of the dealers, they're affiliates of the manufacturers.
That is correct.
Who are we talking about? What kind of affiliates do you have that
They're,
need to be
they're
included?
as with any big corporation or whatever, you've got affiliates. And when I mean affiliates, they could be part of the company itself. But what they're called is affiliates because I was trying to think of a quick example of some, they're through contract or mainly agreement, they're kind of part of the manufacturer, but we call them, there might be an affiliate. And all this was doing was making sure that we cover anybody, since we were in a different section of data, and we did not do that in the prior one, since we were moving into there, making sure that if we're tying these things to this, that we cover anybody that may be under the control. And these people are under control of the manufacturer.
So are you talking about some company that manages or gathers the data for you?
It could be, but it's not necessarily data companies. It could be another company that provides services to us, and they, by providing services, maybe they have some data there. Maybe it's kind of hard to explain. We want to make sure that we cover anybody that we're responsible for.
Okay. When Leader Gooch and I spent a good bit of time a couple of years ago looking into how are we going to provide electricity, charging stations for all these electric vehicles that are now being manufactured in Georgia. A lot of the automobile dealers came to our meetings and they were rather freaked out about the possibility that some of the manufacturers might create an affiliate or subsidiary to manufacture electric vehicles and circumvent the dealership system. Let's say, for an example, the Ford F-150 Lightning becomes the rage, and they started selling them through an affiliate rather than through the Ford dealers. Is that one of the types of affiliates we can be talking about here, or not?
No, sir, and we're totally opposed to direct sales.
Okay.
That is part of our thing. That has nothing to do with what an affiliate would be.
Okay.
That actually would have to be a totally separate company somewhere to do something like that, but that ain't gonna happen.
Okay.
Do we have arguments with dealers? Yes. But we can't live without dealers. And that's our argument when you talk about direct sales.
And that was their fear that you would be living without them.
Yes, sir.
Yeah.
Mhm.
Okay. Allocations. That's a section here Senator Brass mentioned. Tell us how manufacturers allocate their products amongst the dealers. You manufacture 100,000, Lexus automobiles this year. How did we know that, Mike's Lexus dealership gets them versus Leah's or whatever? How does that work?
It's pretty complex, and no, I can't totally answer that,
Okay.
Mr. Chairman, because it's different kind of for every company as they go through. What I can tell you, and we talked about this on the allocation, is you've got so many vehicles that are, say, coming to Georgia for the dealers. What you're supplying, I'm gonna supply if Senator Kennedy has a dealership and he's selling pretty strongly, I've got to make sure he's got enough cars to do that, and I'm allocating from what he did last year. If Senator Summers is not selling too well and all like that, and he said, well, he's got a lot of them laid up there, then, you know, I don't want to allocate that way. Also, even more so is, you know, he might be saying, but all I want is pickup trucks. All I want is pickup trucks. Well, you're trying to sell all kinds of cars, so you're doing the allocation. Now, the problem with allocation is, and we've talked about that, and Ben did a good job of trying to explain it, and we've gone to our manufacturers, is that, you know, we need some more explaining to each dealer. Now, GM has got a program out there right now trying to do that, explaining how we do the allocation. Because the problem is, if I take a car from Senator Kennedy and give it over to, you know, something, there's only so many cars that go around. And so it's kind of like you're going to make some people happy and some people not happy. So yes, it needs to be explained better, but each manufacturer has got to do that, and each dealer has got to understand, you know, what we're trying to do.
Okay. At page 13 on line 311, it says, upon written request of the dealer, the franchisor shall communicate its allocation process in writing in a clear and concise manner within 30 days from the receipt of the request. Is that what you're talking about? You have to, if they ask you, man, how come I ain't getting any cars? You got to tell them, here's the process we're following.
And that ought to be done up front before they ask.
Okay.
And that's what we've gone to the manufacturers to say. You know, look, you need it's hard to go to every single dealer and explain, but, you know, it's a kind of a joint effort between us and the association to get out there and let's explain to people, let's explain to the GM, you know, dealers what they do.
Okay.
Yes, that's kind of the stopgap, you know, if you want to do
It's
it.
new language that
Yeah.
wasn't in the previous, which made me
Correct.
think the dealers must have said, hey, man, we need to be, at least
Where-
tell us why we're not getting vehicles or how you're deciding
Yeah.
where they go.
And they are, and they're talking about, a lot of it came from the pandemic because you end up having
Okay.
things involved. And
That
it
makes
is
sense.
new language, and it's kind of the stopgap, but it's hard to write it in the law what the
Okay.
allocation ought to be.
Well, for everybody's comfort, line 314 says it has to be fair and equitable to all line make dealers in the state. So
Yes, sir.
this makes you have to be fair and equitable in the way you allocate them. And then I
Correct.
think after that, it gives you an excuse if we've had a supply chain disruption
Yeah.
for something out of your control and you can't meet your quotas or whatever, then you're off the hook. But you've done your
You
best.
can,
Good
yeah.
thing. Okay.
But they can still yell at us.
All right. I understood. That's all that I have. Any other members have questions? Thank you. You've been very helpful.
All right, thank you.
Anybody else got questions? All right, we got one more. Reagan Marsh. And you represent General Motors. Let's hear your
Yes, sir, Mr.
viewpoints on
Chairman.
this bill.
Mr. Chairman, members of the committee, I just want to get up here and express my support for the amendment. Thank the sponsor for working with us on this, and also the GADA. I can't answer one of the questions about affiliates. That is generally an entity that is wholly owned and operated by a manufacturer. For example, with GM, you would recognize AC Delco, OnStar, or GM Financial. And I'm happy to take any other questions, Mr. Chairman.
What do you guys do with all this data? What does GM do? Because I know from the black boxes and all, you can tell how fast somebody's going, where they went, you know, did they wreck into somebody, and, you know, what's going on. How do you use that? And does it have a commercial value to you? Can you sell it? Or why is it yours and not the dealer? Why can't they have it?
I'm not sure. I don't have an answer to that question. I can get you one. I mean, I'm sure there's some value to it, but I'm not sure how it's used.
Okay. If the dealers know, or if, you represent all the manufacturers, tell us how they do it, Rusty.
And when you say data, there's our data, they have data. I mean, it's not like we have this big pool of data and then they have their own in some ways.
The dealer
and they,
does.
Yes, and
'Cause they want to know
and
when
that's
you come
what-
in to get your oil change so they can send you a
Correct.
request to come get it.
And that's what they're, we talk about backing up, that's what they want to back up, is what their data is. We have data that goes back to us. I mean, it's not necessarily sitting at the dealer somewhere and all like that. And what we're looking at is, you know, how does the car operate and things like that.
Okay.
It's not really, you know, there's a lot of retail, I guess, repair people that would love to get that data, but we don't sell that, we don't give that to them because that's something that we have. No, it's not a problem. And a lot of what you're talking about is also data that people like AAA and insurance companies want, and they have their own sources to get that.
I
So
wonder
it's
if
a kind
anybody's-
of different pots.
Is anybody worried about the consumer, the person that owns the car? All this information's being gathered on their vehicle and they don't even have access to it?
It is, but necessarily, do you want, I mean, you have access a lot of it because I imagine if you've got a car right now and you get up there, they tell you, you know, what your tire pressure is. They tell you when you're supposed
Yep.
to get in. If
My
the
engine
engine's-
light's on right now.
They,
I
I
don't
know.
know what it is.
If they,
Keeps
I mean,
running.
So, what good does it do if you don't know? No. You have that. Most consumers have access to all of that, and you even get more from some of your insurance companies. Most of them don't want it because they don't want to know what's the problem in your engine is and all like that. Thank you,
Thanks.
Mr. Chairman.
Appreciate it. And nobody else had a question, I don't think. Thank you, Mr. Marsh. If you're through, that is all the testimony people that were signed up. But if anybody else here has a particular interest in this subject matter, now's your shot. Speak now or forever hold your peace. All right. Any further wrap up for you, Chairman Brass? If you'd like to make any comments, or are there any further questions for you? Now's your time.
No, Mr. Chairman, other than, you know, you had brought up the direct sales, and that seemed to be a little bit of a topic. And, of course, serving on this committee for the last, I believe, I'm in my 7th year on it, and so been close to that debate. And I remember at the time of one of the debates, one of my dealers reached out to me, and he told me, he said, Matt, we employ about 70 or 80 employees at an average salary of between $70,000 and $75,000 a year. And, you know, I got to thinking about it and thinking about how many dealerships I have just in my district. And then I thought about how many manufacturers I have in my district, and I don't have any. And, you know, I look around this room, and I would venture to guess that we all have a dealership, at least one dealership in our district, if not multiples, and not all of us, you know, are fortunate enough to have a manufacturer in our district. And so that just kind of put things in perspective for me. But I have seen how a manufacturing plant can revitalize a community, as we saw with Kia down at West Point, Georgia. So there's value in both manufacturing, value in the franchise. We have a system that works that for us as legislators, we all want jobs. We want opportunity for our constituents, and in both manufacturers and franchisees and even the affiliates all provide that. And so when we can get them together and come to an agreement, you know, I think it's helps move the state forward. And I'll comment too, I think, on the need for the legislation now. As you can tell in the bill, and you've commented, the biggest portion of the bill is around that data protection. And, you know, we saw when that system went down, you know, it affected a lot of people, a lot of jobs, and a lot of revenue. And I think that is the importance of this bill and why it's needed now, and would encourage and hope for positive outcomes here.
Okay. Any further questions from committee members? What's the pleasure of the committee? Y'all ready to consider this today? You need more information? Yeah.
Considering the enormous amount of time that we put into this already, I don't want to delay it any longer. I'd like to make a motion.
You are recognized for a motion.
I'd like to make a motion to pass Senate Bill 81, LC number 394551.
Senator Kennedy, you're recognized.
Second.
All right, we got a motion and a second. Is there any discussion?
With the amendments
Or
as
any-
proposed.
That's a good point. I was about to say any amendments, but we know the one you've proposed. I'm going to call that Amendment 1. Senator Brass, will be your amendment, and that is working off of AM 390443. You're recognized to formally propose that amendment.
Mr. Chairman, make a motion that we pass Amendment 1 AM 390443 as
Is there a
written.
second?
Second.
Second by Senator Gooch. Any discussion on the amendment? All right, all in favor, raise your hand. All opposed, raise your hand. All right, that is unanimous, ladies, if you'll make a note of that. Now, we have the bill as amended, so we will vote on that motion from Senator Gooch to do pass Senate Bill 81, LC 394551, as amended by AM 390443. Any discussion on that? All right, all in favor, raise your hand. And any opposed, do the same. It passes unanimous. Thank you, Mr. Rules Chairman. Well done. Thank you, everybody, for your giving us the very specialized information on an area that none of us are experts on up here. Senator Butch Miller was an expert when he was here, and he hadn't even weighed in on this bill. He hadn't even called us. All righty. I'm moving to the next bill. Senator Huffstetler, we're going to get back to you, but we got a quick one first. I'm going to call my seatmate, Senator Clint Dixon, who guards my right flank throughout all the session.
Thank you, Mr. Chairman. I appreciate all the wisdom you've bestowed upon me during this session.
You're going to be a suck-up. All right.
Make a motion right now.
You already got your bill heard. Let's see what you got. Okay. Okay. All right, we're on Senate Bill 112.
Yes, sir, Mr. Chairman.
All right, let's go.
Thank you, Mr. Chairman, committee members. I bring Senate Bill 112 before you today. What it has to do with is HVAC system warranties. And I'll use an example. The bill does three things, but say you purchase the HVAC system from a licensed contractor and you purchase a 10-year warranty on it. Currently, what you have to do is you have to register that product with the manufacturer, which is a step that's unnecessary in my opinion. That's just an extra step. The manufacturer, once you purchase that warranty, already has your information. This would do away with that. Upon installation by a licensed contractor, that warranty would start then. There would be no need for that extra step to register that product. It also would make the warranty transferable. So if you had that 10-year warranty and 5 years into it, you sold your house, that warranty would follow the unit and not the purchaser of that. So it would continue on with a new purchaser, whether the house was sold one time or 5 times in that 10-year period.
Get my mic working. Question about Senator Summers.
Chairman Dixon, make sure I understand what you said. When you buy a new HVAC system, and I'm quite aware of all this, you basically get a 10-year warranty on the system, not on parts and labor. Are you saying an additional 10 years if they buy an additional 10-year warranty, or how is it? So whatever they buy, they'd get the full coverage?
Yeah, and so most manufacturer warranties, if there's not an additional warranty purchase, usually a year warranty on it. If you purchase that additional warranty, and it may not be 10 years, it may be 5 years, whatever it is. I was just using that as an example.
Okay.
But when you buy that additional warranty, you have to register the product
Right.
with the manufacturer, but the manufacturer already has your information because, number one, you bought the product from them, and then you've also purchased that extended warranty.
And
Go ahead.
and the new homeowner or the new whatever purchaser, whoever buys the would not do anything except just basically pick up the phone and call on that warranty under your bill. They would get the HVAC unit fixed or whatever.
That's correct. So, yeah, so under this bill, what it would change would be that once you purchase the warranty from the manufacturer, which then they would have all your information, when the product was installed at your property with HVAC system, once it's installed by a licensed contractor, that would be the start date of your warranty. So when the installation date would start it, and you wouldn't have to take that extra step registering the product. And we've had several instances in the state where folks have failed to do that. You get busy. Sometimes it's cumbersome. Sometimes you might lose that information, especially if you're building a house. And manufacturers, in some cases, have not honored those warranties that they've already purchased.
One problem, Mr. Chairman. Does that apply only to commercial or residential, or will it apply to commercial also?
It doesn't specify as far as, it just applies to HVAC systems.
Just HVAC system in
Yes,
general?
sir. That's correct. And I've got Tucker Green here with us.
Mr. Green, if you would take the podium, we're going to try to speed this up because I'm getting pressure now. Education Committee apparently is headed our way. Tucker Green.
Thank you, Mr. Chairman. Members of the committee, on behalf of the Conditioned Air Association of Georgia, we fully support this bill. Very quickly, Florida passed a very similar piece of legislation. We heard a lot of feedback from contractors that do business in both states that we thought this would be a good idea to help solve some issues we were seeing in this state. As Chairman Dixon stated, it's really a consumer protection so that if they forget to register that warranty that they've already purchased or something like that, they're covered if they've purchased that warranty, as well as transferring properties and things like that. It helps contractors as well because then they don't have the burden of, is it our responsibility to register these systems? Is it the customer's burden to do that? It really helps kind of take out a lot of the confusion of the process, streamline, and make sure that these warranties that have been purchased do protect and cover the equipment.
Any other questions for Mr. Green? All righty. What's the pleasure of the committee on this bill?
Motion to pass, Mr. Chairman.
Got one motion in 4 seconds. Sounds like this has pretty good support. I heard Senator Brass's voice first, so he's going to get credit for the second. And is there any discussion or any proposed amendments? All right, all in favor of this bill? What is our number again? This is 112. I'm trying to get the LC number. There we go. LC 600068. Raise your hand. Are there any opposed? You're not allowed to abstain, Senator Rett. You're a yay or a nay. All right. Is that a yes or a no? All righty. It's unanimous. Senator Hickman, did I see you in the crowd? Well, let's see if he's found another room.
Thank you, Mr. Chairman.
Senator Billy Hickman, the racehorse king of South Georgia. Come on in. All right, Senator Hufstad will come ahead. If he walks in, we're going to adjourn as soon as he walks in the room because education is assigned this room. All right. 5:15. I saw him poke his head in earlier, and I thought he was he's probably going, complaining to the Lieutenant Governor right now.
All right, thank you, Mr. Chairman. You know, I heard data and data. My son says he's got a degree in finance. I say I'm the chair of finance, so we have opposites on that too. And I will say on your Life 360, there's a privacy setting. You can opt out of them selling your data. If you've got that on your phone, you might want to do that too.
Are you in
if
the
you're a
Four
bad
Corners
driver.
defense? Are you stalling this?
No, I'm not stalling it, but I was going to throw that in. I passed this bill last year out of the committee unanimously. We passed it out of the Senate 53-0 unanimously. I would like to get it over the House again. I did meet with the Public Service Commission, and they felt like this should be under the law department. We've got 46 states that have an organization where it's independent. I think the way I did it's independent. However, I'm agreeable to that amendment if they want to do it. So I would agree with them on that amendment, and I would like to see if we had testimony last year on this, if we could get this back out, same as we did last year.
All right, I have in our files this amendment. I thought it came from you, but it came from PSC.
Well, it came from me, but it was at their suggestion.
All right, that's AM 550069. All right, I see Tom Bond from PSC was signed up to talk to us. Hey, there he is. Would you like to speak to it just briefly to us and let us know what your view is of it, and have you seen the amendment? Does it suit you? You can sit right there, be fine.
Have not seen the amendment. I'm Tom Bond, Director of Utilities at the Commission. We appreciate the change. It's our understanding that the change has this under the Attorney General's office rather than the Commission. We had seen some potential conflicts with having them under the Commission. You know, so like I said, we do appreciate that change. That said, the commission is, you know, doesn't think that you necessarily need a CUC. The commission already has a public interest advocacy staff that participates in contested cases as a party. They independently evaluate rate requests and look at them from the standpoint of the public interest, engage in extensive discovery, present expert testimony, cross-examine witnesses, and make independent recommendations on what rates should be just and reasonable and are in the public interest. Of course, you know, it's your decision. If you want to bring back the CUC, you certainly can, and we do appreciate the change to have them under the Attorney General's office rather than the commission.
Why do you prefer that?
Well, two reasons. One, the way there's a national association of CUCs called NASUCA, and you cannot join NASUCA if, as we read their constitution, if you're under the administration of a public service commission. So if you're going to go to the trouble to create a CUC, you don't want to risk jeopardizing their ability to join with the other CUCs in their national association. So that's one reason.
Well, what's up? But I thought putting Attorney General would jeopardize that.
No, putting them under the commission would jeopardize it.
Okay.
Their constitution specifically says if you're under, you know, if you're under the office has to operate independently of its respective state utility regulatory commission with respect to, and it
Okay.
includes personnel and fiscal control.
So the
If they're
Attorney
under the
General-
commission for administrative purposes, we assume they're using our fiscal office and whatnot. And that, we think, would risk not allowing them to be part of the National Association.
So the Attorney General's office could join that organization, and you think that's an advantage?
To be part of the National Association? Well,
Yeah.
when you hear the number, there's 46 other states that do it. That's what they're talking about. There's 46 other states that have members of NASUCA. So,
All right.
so that's how we read it. The other reason is completely different. You know, if they're under the commission, our concern would be that you'd have a competition for resources under the same, you know, administrative support. The commission already has a public interest advocacy staff that advocates in the public interest. We already spend the maximum amount we're allowed to by law when we do utility rate cases. We already utilize everybody on our staff to work on those rate cases. If you have, you know, two entities with similar functions under the same agency, our concern is you'd have this, well, y'all just share your resources, and then instead of us being able to present a public interest case that's rigorous, we'd have duplication. You know, we do a complete case. We cover in a rate case everything from affiliate transactions, return on equity, depreciation, O&M, all of those things we cover. And if, say, 10% of our resources were diverted to somebody else, odds are they're going to duplicate something we're already recovering, and there's going to be another category of costs that nobody looks at.
All right, so let me make sure. We used to have this position
Right.
until what year?
2008.
Yeah.
Till 2008, and now your Public Service Commission is opposed to creating this position even though 46 other states have it.
We're not opposed to it.
Okay.
We just think it's redundant.
All right.
But
If you
that's-
think you're already doing the job well enough with your own internal folks.
Yeah.
Okay.
Yeah, but
And if we do it, you'd rather it be with the AG's office so it can join this national organization with the 46 other states and be independent of you.
Right. If you're going to do it right.
All right. Senator Brass, you got a question?
Does the author or yourself know why we eliminated it in 2008?
I think it was the recession, and they were looking at a lot of positions back in 2008 and eliminated this one. And, you know, I do think it's important that they are independent, and I don't feel like there's redundancy here. I think the independence is very important
Follow
to join
up,
the other
Mr. Chairman.
46 states.
Follow up.
And so what was the cost then, and what's the anticipated cost now?
I think, well, this is going to be subject to appropriations. I think we're looking at under $1 million for a complete staff. I think they can start out with less than that. You know, and I think that's a small amount to take care of an independent voice for the consumers with the billions of dollars that are out there on this.
Can that independent voice not go testify on? But
Well, they don't have legal standing right now. This gives them legal standing to represent the consumers who really haven't had that independent legal standing.
Senator Kennedy, you're recognized for a question.
Thank you, Mr. Chairman. Thank you, Chairman Huffstetler. Can you unpack that $1 million figure a little bit for me? And what would $1 million go to, or
you're going to probably have an attorney, unfortunately, that.
Well, I think the statute actually requires it to be an attorney, as
yeah.
you have proposed this, so
Yes.
don't blame me for that, all right?
But they would probably have, you know, a support staff and maybe a couple of experts in finance that would be working with them. So it would be several people. I think at one time they were up to about 6 people.
Sort of bootstrapping off what Tom said, is there a way we can utilize the resources of the PSC if they have that expertise, so there's not a redundancy of those positions and the cost? And that may get into creating problems of what you're talking about that needs to be separated. But if one or both of y'all could address that, that may help me understand the efficiencies that may go along with this.
Well, you know, from the commission standpoint, you know, like I said, I mean, we're already sort of at maximum. Everybody, when we have, so this year, you know, we've got a IRP and a Georgia Power rate case on our agenda. Everybody at the commission that understands integrated resource planning is already working full-time on that IRP. When we get to the rate case, they're going to be working full-time on that. We've got a maximum outside budget of about $800,000 for each of those cases, and we're spending to the max of that. Because we're going to have, you know, we've got about 9 outside consultants that specialize in transmission planning, in forecasting, in computer modeling, and things like that that we're planning to present. So, you know, if we have to share those resources, you've got 2 problems. One is less resources for us. 2, our resources testify. So if their testimony is going to be exactly the same as ours, sure, we could use the same witness and say the exact same thing, but what's the point of that? If the testimony is different, I can't put up, you know, my witness and have them say X, and then CUC puts them up a day later and they say something different. I mean, that's not a workable, you know, because it's sworn testimony. They can't just switch depending on which party they're representing at the moment. That's why, you know, there needs to be complete separation.
Well, I would say the lack of independence is very important. I think we've seen, and I put some numbers in your folder there of our rates, you know, showing we're in the top 5 consumer rates in the country, and that has happened over, you know, the last 10 or so years. And I think that's why these states see the independence of it. I've actually got a 1988 report, Office of the Consumer Utility Council, that went to Governor Joe Frank Harris, who's one of my constituents, and to the Public Utilities Committee of the State Senate. And they intervened on some issues, and, you know, in some cases, I looked at one of them. Well, Georgia Power was charging more in their rate base for property taxes, and they were actually collecting. Things like that they get involved in that I think would be very helpful for the consumers to have a voice. It's a very small amount of money in the billions of dollars to let them have a voice.
Mr. Bond, would your cost at the PSC go down if the AG's office began doing some of the tasks that you guys have been doing, protecting the consumer? You may not need to spend that $1 million if
I mean, here
somebody else is doing the work.
The concern I have, I went back and I looked at the last 2 rate cases that CUC worked on for Georgia Power, the 2004 and the 2007 Georgia Power cases. All right, in the 2004, CUC's recommendation of disallowances in that case was $0. Staff's recommendation was $385 million. In the 2007 case, CUC's recommendation of disallowances was $6 million. Staff's recommendation was $427 million. So to say that having CUC come in and get lower rates is just completely contrary to the history of how that organization worked. That's not what they ever did.
Okay. Well, what about when you guys, staff makes recommendations to PSC and they ignore you guys routinely? You're doing the same thing the CUC was doing. You're recommending different rates and charges, and the PSC seems to just go ahead and ignore you guys most of the time and do what they want to do.
Well, the commission has never in my time there had a rate case where they adopted 100% of the staff's recommendation. But they have never had a rate case where they adopted 100% of the company's recommendation. You know, they act as a judicial body. They make decisions that are typically somewhere in between. You know, in the last Georgia Power rate case, Georgia Power had requested, I believe, over a 3-year period, an additional $2.5 billion in revenue from ratepayers. And the staff put on a case, and the commission ended up cutting 40% of Georgia Power's request. In the Vogel monitoring case, the company spent $10 billion in capital, and staff recommended disallowing over $3 billion in capital costs and another couple billion in financing costs. And
How much
that's
did the
what happened.
PSC disallow? They took your advice on that? Okay. All right, other members, Senator Ginn, do you have a question?
Yes, sir, Mr. Chairman. And I could pick on our dean of the Senate or his seatmate over there, said Senator Sims, or I could pick on our chairman, because I believe the three of y'all were the only three on our committee that were here in 2008. And I think about the state's economy, the state's budget, the tightening of the belt and everything there, and I was kind of curious, was this commission decommissioned because of the tightening of the belt in the state budget, or do you have any insight into that? I was kind of curious if it.
I wish my memory was that good, and I hate to be incorrect, but I can tell you this much. We get these books that have 400 pages now of additions to the budget. In 2009 and 2010, we weren't getting books. We were being told, go dig in the weeds, find something being spent, and cut it if it's not mandatory and necessary. And it was quite the experience, and it was healthy in the long run, because you got to look at the budget that wasn't just the changes, the additions to the budget. So that very well could be where we came out to that, because we were cutting anything more than just fat. We were cutting into the muscle, just trying not to get to the bone on some of those things. Right, Mr. Dean? All right. Senator Brass, recognized for a question.
I'm just a little confused on.
Not an is it true question either. One of those.
All right,
is really a
I'm
question.
confused on the mechanics of how all this works, and I'll get to my question, but don't PSC members represent consumers just like each one of us? We represent consumers.
Yeah, and that's one of the reasons that commissioners don't think that this is necessary, is that's part of their job. They're hearing from staff already, they're hearing from the company already. In a rate case, they typically hear from about 20 interveners who have, also have the right to put on witnesses, cross-examine, and whatnot. And then the commission, who are elected by the people, make the decision. So there's some natural.
But I guess this next question is for the bill author. I mean, so in your mind, the state is going to pay for someone to represent consumers, and I guess my question is, which consumers?
Well,
We represent consumers, and I've yet to find an issue where everybody I represent agree on it. So how do they select which consumers they're representing?
You're representing the consumers and their rate, and are they being treated equally in the rate? And, 46 states have seen the wisdom of having an independent person looking out for the consumer that has legal standing.
But
And
what happens when half the consumers think there's a problem and half of them don't?
Well, I don't think half the consumers are going to say, I think my rate should be higher. I mean, they're generally going to agree on all that. I think that they want to look at, what's the best rate for them, what's the fairest rate for them.
I'm just confused as why, I mean, I can understand the wisdom of the legislature in 2008 on making this cut, because you're paying for representation when you're also on the other side paying for representation for the PSC members. And so you're paying for two sets of representation to fight against each other, essentially, is the way I'm reading this. Am I reading that? Can you
Well, I would
help me
say,
work through that?
I would say that the rates of Georgia relative to other states changed after 2008, that they, whether this position did it or not, maybe that's up for discussion, but there was a change in the rates. Ours started going significantly higher, and now we're in the top 5 in the country on consumer bills. And so I think the commission, the Public Service Commission, is trying to address that with some of the things they're looking at, but I think having somebody in legal standing that intervened in some of these cases helped out the consumers.
Okay.
Senator Kennedy, you're recognized for a question.
Thank you, Mr. Chairman. And this question may be for Mr. Bond or Chairman Huffstatler, whoever might can answer it. So we would have this additional level of cost, the administrative cost to set it up and run it as was expected. And Mr. Bond, listening to you brings the question in my mind of, in addition to that, this is where I have no idea how this works when this entity intervenes in the process. And when you've seen it happen in the past, or Chairman, if you know, if you observed it or read about it, does that then, I could foresee, naturally require some sort of responsive action or management on behalf of the utility, which then consumes resources from their standpoint to not only be dealing to interface with the PSC, but now they're being forced, if you will, because this is a recognized entity, being forced to deal with and respond to this consumer entity as well. And what does that look like, and how much does that drive up the expenses? Because what ultimately then gets put on the utility ultimately gets passed on to the consumers as well. And that may be a little burden, or maybe it's not so little. And do you have some sense of, can you describe for us what that looks like?
Well, you know, CUC used to have, and I believe would have under this legislation, discovery rights. So, you know, whenever you have another party with discovery rights issuing data requests and interrogatories and things like that, I would assume the company is going to have, you know, costs associated with that. But I couldn't quantify what kind of impact CUC's discovery might have or have had on the company.
I think a lot of people have legal standing right now in these rate cases, and I think that somebody representing the consumers, you know, has proven effective in all these states that do it. And I think the cost is sort of a red herring when you're talking about the billions of dollars out there and the stuff we do. I think this is a very small cost to have somebody that represents the consumers.
Any further questions? All right, what's the pleasure of the committee? Got a motion to pass from Senator Rett and a second from Senator Jones. Is there any discussion, or would anybody like to propose this amendment that requires a committee member to appoint, that lets the Attorney General's office manage that position rather than the...
Do you want me to read the amendment?
I'm looking for my copy of it. I think I might have just given it away to the last speaker, but yes, I would like you to.
This would
We'll
be
call it Amendment 1.
This would be replacing lines 44 and 45 with the following. There is created the office of the Consumer Utility Counsel, which shall be assigned to the Department of Law for administrative purposes only, as provided in Code Section 50-4-3. There is created the position of director, and then it continues from there.
All right, and that's contained in AM 550069. Any discussion, or anybody, I guess we have that. Anybody want to proffer that amendment?
I'll proffer that.
Okay. Minority Leader.
Amend lines 44 and 45 with the language that was just stated on Amendment 1.
All right, is there a second? Second by Senator Redd. All in favor, raise your hand. Yes, just on the amendment only. All right, well, you got that count? All right, any opposed? None opposed. All right, that is unanimously adopted, so now we're back to the underlying bill as amended, and that's Senate Bill 94 LC 550447, as amended by AM 550069. Any discussion on the bill as amended? All right, all in favor, raise your hand. 1, 2, 3, 4, 5 in favor, all opposed? 5 and 5. I'll break the tie in your favor, Mr. Chairman. I'll mark my vote as a yes.
Thank you, Mr.
This will
Chairman.
move on to the Rules Committee. Yes. All right. Excuse me? No. I might have made a comment I shouldn't have made earlier. I made a little kind of a smart aleck comment about senators requesting bills and then changing their mind and not wanting the hearing. That's not a fair comment on this next bill because I did not consult with the author before I put it on the agenda. Sometimes for legitimate reasons, senators want to line up testimony, et cetera, and I just put it on there trying to be a friend and helpful because it seemed uncontroversial, and I did not consult with Senator Walker before I did that. So my apologies to him if that was construed as a little smart aleck comment. I didn't mean it that way. Any of you that have bills in our committee that you want a hearing, please let me or my office know. We're about to get crunched on time. I'm planning on Thursday, I'll probably hear one bill, and we're going to have an update on broadband expansion. A number of people in the various industries that are collaborating to get broadband expanded throughout Georgia are coming to speak and let us know what a wonderful job we've done and the state of Georgia has done with federal assistance to improve that situation over the last few years. Next week I'll be having bills on both days. I'm not certain what we're going to be hearing which, but I'm waiting on folks here to request their bills, and then I'll try to weigh the urgency of them and whether or not we've heard enough information to make rational decisions. Again, we'll be having a committee dinner looking to be February 26th at the 57th Fighter Group. We've been the last couple of years. Any lobbyists that are interested in helping us sponsor that and attending, please check with Paige in 432 down the hall, and we'd love your participation and attendance. And members, please mark your calendars, save that date. All right, we are adjourned. Thank you.